Circuit Court in the booth. With me today, between the speaker and me standing here, is Prosecuting Attorney of Stoddard County, Russ, and he will come up and tell you about the petition he filed. Basically, it is a petition asking the court for a declaratory judgment that as a matter of law, state statutes are being violated in the collection and transmission of certain data by the fee office agents across our state. This is new, at least it's new to us. When folks from the Department of Revenue arrived at the fee office and told the agent they were installing new equipment, I guess a new software. The petition again was filed this morning asking for declaratory judgment that the statutes of our state have been violated and for a restraining order against continued violation. So with that, I will introduce my friend Russell Oliver from Stoddard County and ask him to talk about the petition he filed.
As Peter mentioned, today a lawsuit was filed attempting to remove a new and illegal impediment to this state's citizens' right to obtain a concealed carry permit. The plaintiff is a resident of Advance, Missouri. He is a farrier by trade. He wanted to get a concealed carry because he has a small pistol that he doesn't plan on carrying very often, but in case he wanted to obtain a concealed carry. He performed all the legal requirements necessary to obtain the permit. He was approved by the sheriff after a background check. He completed all requirements of the statute for training and everything that was required by statute. However, when I got to the local license bureau, there was a new hurdle that hadn't been there before. This new hurdle was that he had to provide his personal documents, including the application to become a concealed carry endorsement holder, that he had to provide these documents for them to be scanned. It's our opinion and the lawsuit's position that this is a violation of state statute. Section 32.091 prevents the collection of any personal information by the Department of Revenue or their fee office agents. Previously, the offices would obtain the documents from the applicant, look at them, check the box, and return them to the applicant. That is what the statute prescribes. They're no longer doing that. About a month ago, this new equipment came in, and the fee office agents were instructed to scan the documents and to retain them within the Department of Revenue's system. This equipment has been provided by a private company named Morpho Trust USA. We are uncertain how this equipment or the contracting went on with DOR to obtain this equipment from this private company. However, this private company holds itself out as specializing in partnering with federal agencies and state agencies in creating secure identification. It appears from what we've gathered so far that the Department of Revenue and the local fee office agents are attempting to comply with the Federal Real ID Act of 2005. This act says that for state IDs to get certain deference, the states have to do certain things. However, the state legislature clearly opted out of the Federal Real ID Act of 2005 through the enactment of 302.183, which clearly mandates that the local offices and the Department of Revenue are not to obtain or amend their procedures in order to comply with the Federal Real ID Act. This statute, it's our position this statute is not subject to supremacy clause issues in that it's an optional compliance statute and has no regulatory scheme. The clear mandate of 302.183 makes it clear that what is going on here is improper, illegal, and is a new and illegal impediment to to citizens' rights to obtain a concealed carry permit. This practice also serves no legitimate purpose. 571.121 clearly states that the Department of Revenue and the fee office agents are acting merely as scriveners in the process of the CCW application. What that means is that the sole responsibility of determining whether someone is a proper applicant for a concealed carry permit is the county sheriff. There is no discretion, no decision-making process that DOR or the local fee agents have to comply with. This is merely a ministerial act, and there is no legitimate purpose for them to be retaining such information. Again, it is our position and the lawsuit's position that DOR and the fee office agents have created an illegal hurdle that all applicants across the state of Missouri for a concealed carry permit should not have to overcome. I'd be happy to entertain any questions.
Did you file your lawsuit in your official capacity or as a private attorney?
No, as a private attorney.
In terms of the hurdle for the CCW permits, is that become an issue because of the procedures for obtaining a driver's license and the endorsement is on a driver's license?
That's correct. My client went in to the local fee office and went to apply. They informed him that his documents would have to be scanned. He said he didn't want to do that, and they said, well, you can't get your CCW. So this is clearly a hurdle that someone has to overcome to obtain a concealed carry endorsement on their driver's license.
When did he, how recently was he seeking to have that happen? Was that?
Happened very recently, yes. I believe that he went in this morning, and the lawsuit was filed immediately thereafter.
Any idea how long this has been going on?
I can't say with any specificity, but I've been informed that these machines showed up about a month ago.
Okay. Are they everywhere across the state, or?
That I can't speak to. I know that they're in the Stoddard County fee office. Past that, I don't know. I've heard rumor that they started in the Kansas City area and now have been incorporated throughout the state.
To underscore a point that Russ made in different language, the legislature faced an option 10 years ago on the passage of the right to carry law. Will we have a may issue law or will we have a shall issue law? Some states have may issue, investing the sheriff or some other public official with discretion. I will grant this person a permit, but not that person. That's not our law. Ours is a shall issue. It's a mandate. You go down the checklist of requirements to secure a permit, and you get one. It is not discretionary with the sheriff or any other public official.
Mr. Oliver, what is, I guess, what is the concern with having the documents be scanned?
Statute clearly makes the application itself a personal protected private information. It is being uploaded to at least one third party in this private company, and from there we don't know where it's going. But the simple fact of the matter is that my client shouldn't be required to provide this information to be scanned, and he shouldn't be required to put his personal information in jeopardy.
Do you guys know how many other people have actually gone through with scanning and gone through with this?
I don't know, and it would be anyone that has applied and obtained their permit within that time frame.
Maybe about a month.
Possibly.
And so you're saying the bottom line issue is that it is illegal when it comes to the statute?
Correct.
And then you don't know where this information is going?
Correct. Any other questions? Mr. Speaker, I didn't mean to take the floor from you.
Not at all. Okay.
I thank you all for your time.
Thank you all for coming, and we'll get out of here before your caucus.
That's right. Thank you.